we're just giving everyone a minute to log in, and we'll be.
Thank you to everyone that has joined us today for our webinar, Emerging International Dispute Trends Relating to COVID-19, where we will be discussing trends in commercial and international investment arbitration. My name is Sean Stevenson, and I'm a senior associate from the Denton's Toronto office with a practice focusing on international trade and international arbitration. And joining me today, we also have Kristen Weil, a partner in the dispute resolution practice. His practice focuses on international arbitration and litigation, and Diora Zaeva, a senior managing associate whose practice also focuses on international arbitration with a specific focus on investment arbitration. Both Kristen and Diora are both joining us from Denton's New York office. Before we get started, before we jump right into the presentation, we do have a few housekeeping notes. Only the panelists will have the ability to speak throughout the presentation. If you have any questions you would like to ask the panel, please feel free to submit them throughout the session via the Q&A button. And maybe we can all just take a brief moment to locate that Q&A button right now. Please also note that the presentation is recorded and will be made available with the slide deck following the webinar. For those seeking CLE credit, the webinar window must remain open for the entirety of the program, and it must be the only window on the forefront of your screen. WebEx will detect if you minimize the program or use the computer outside of the webinar software, and this will prevent you from earning your CLE credit. For those of us joining specifically from New York or New Jersey and would like to gain those CLE credits, be sure to listen for the code word, which will be given during the program. When prompted, you need to enter the code word into the Q&A section of the screen, and again, that will be to validate your CLE credits. Now that we had those few housekeeping rules comments out of the way, I think we can get right to the crux of the presentation, and I'm going to pass it off to Diora.
Thank you, Sean. Good afternoon, everyone. Thank you for joining us today. We hope that you find our presentation useful. You all have by now heard of COVID-19, which has been declared a pandemic by the World Health Organization. As you know, it's an extraordinary event which carries transnational implication and requires immediate international action. It's spread over 170 countries, and at the rate pace that it goes, there are over 1.5, if not more, million confirmed cases. In today's presentation, we will discuss first the implication and impact on COVID on business and trade. You will see that it caused crash in the global stock market, and it's considered by many worst fall since 1987. Sean will cover the points concerning the outlook for global growth and the impact on trade. We will then discuss the impact of COVID-19 on the commercial arbitration context, specifically whether a party's response to COVID-19 pandemic constitutes valid grounds to avoid contractual obligation. You will hear from Kristen that it requires careful analysis of the contract, applicable law, and of course the facts of the case. And we will then discuss the impact of COVID-19 in the investor arbitration context, the measures that are being taken by the state globally to combat COVID-19, certainly form basis for claims by investors, the merits of which will need to be, of course, evaluated as well on the case-by-case basis. So without further ado, let's move into the summary, and I'm passing the floor to Kristen.
Good afternoon, everyone, and thank you for joining us for today's webinar. The COVID-19 pandemic has impacted the global economy in ways that are affecting us immediately and in ways that will likely affect us for a long time to come. Governments around the world have responded to the pandemic in a variety of different ways that are largely unprecedented. This involves providing financial aid to both individuals and companies and redirecting industry resources such as equipment, facilities, and personnel, all in order to try to help fight the virus. Given these unprecedented times, companies engaged in commercial activities, as well as investors who have made investments all around the globe, should be made aware right now about how their commercial rights and their investment treaty rights may be impacted by the COVID-19 pandemic. Diora?
Thank you, Kristen. The impact that we have seen so far, we've seen the disruption of hearings. There's been a number of cancellations, postponement, and a lot of, or I would say majority of the hearings are conducted remotely. We have seen most of the arbitral institutions discontinuing or canceling any arbitration or mediation related activities all the way until to 2021. We have also seen a disruption in means of conducting internal investigations, conducting evidence gathering activities and discovery related activities related to international arbitration. There's been, of course, a potential risk of meeting with people and, in fact, going from one jurisdiction to another. One of the demands that we have seen in light of COVID-19 is a greater than usual demand for emergency relief. As many of you know, emergency relief is a temporary measure which aims to protect the parties in dispute against damage occurring during the course of the arbitration. So we have seen parties applying for that emergency relief. Frequently, it requires a demonstration of irreparable harm and certainly a requirement of urgency and proportionality. So the impact of COVID on the process of dispute resolution we have already seen. And in terms of the silver lining, a lot of people say that it may be a turning point because it brings online dispute resolution to the world of international arbitration. Sean, flow to you.
So just taking a step back to look a little bit more broadly at some of the drivers of the disputes. We'll mention some of them here. Obviously, there's been a significant amount of drivers depending on your industry, your specific sector, or where you're located in the world. But we see disputes specifically trending in the financial sector, as well as the energy sector, as well as a significant number of disputes we anticipate coming from trade or supply chain disruptions. So, for example, in the financial sector, all or most major U.S. indexes have fallen by more than 10%. Here, we believe that when we're coming out of COVID, so in a post-COVID world, we believe there will be a significant rise in international arbitrations in relation to the financial sector, potentially claims made directly against government in litigation, but a significant number of B2B claims that could involve international arbitration. In relation to energy, we note that, at least from a North American perspective, at the beginning of COVID, the energy world was sort of shaken up largely in relation to the oil markets between the Saudi Arabia and Russia dispute, which drove oil prices down to rock bottom levels. At the same time, oil producers and people in the oil industry have also had to fight with a significant reduction in usage of oil, just given the lack of travel, given the lack of daily use of automobiles, given that most people or a significant number of people had been affected by shelter-in-place orders and were not going about their daily routines and not essentially did not have a need or a demand there, which also took a significant toll on the oil industry, notably causing a reasonable or significant amount of production to be stalled and most storage capacity at a maximum. Given that the oil industry had was significantly impacted, there was a secondary impacts, for example, on the shale market and natural gas energy. The U.S. shale market effectively collapsed, with several major shale producers having filed for Chapter 11 protection or other governance assistance. So significant amount of disputes could relate from that that were largely driven by COVID. Now, on a trade and supply chain basis, we anticipate disputes largely stemming from disrupted supply chains. Global trade volumes have significantly moved downwards and to a fairly bleak outlook. We've seen in the first quarter estimates of 5% reduction in trade of merchandise. We are just seeing the numbers coming into the second quarter now, and we're seeing overall a reduction in the realm of 14% below what was anticipated for the year 2020. So significant trade volumes have been reduced. Obviously, if you're doing business and you're looking for inputs, that has been significantly affected, given that global trade volumes have largely been stalled or reduced throughout the COVID period. This has changed depending on where you are and what sector you're in. Energy, obviously, as I noted before, sharply declining. The automotive sector, obviously, significantly impacted as well. Potentially in North America, this was compounded by the implementation of the USMCA, which changed rule of origin requirements for autos. So all of these things are potential or have potential for disputes, particularly international commercial disputes, given the cross-border nature of international trade. We're good to go to the next slide just to give a little bit more indication on those trade volumes. One of the key indicators of the global economy is the east-west shipping routes, i.e. ships coming from Asia to North America or Europe. What we've seen so far in COVID is about a 12% reduction in shipping, which is a historic reduction. So significant trade volumes have been affected. If we go to the next slide, just a little bit more regionally, in Canada, we've seen a significant reduction in trade. So again, those supply chain disruptions, whether it's downstream or upstream, can affect you and can give rise to international commercial disputes. Similarly, if we're to go to the next slide, we've seen a stark reduction in U.S. trade volumes as well. Looking at it pretty specifically, year to date, we've seen about a 14% reduction in exports and about a 13% reduction in U.S. imports. So significant trade volumes that have been affected throughout this entire period. One last thing that is worth noting as well is that while trade has declined, we've also seen trade restrictive measures be put in place. So if we're just to move to the next slide, some of those trade measures can result in commercial disputes, but there's also potential for those measures to result in investment disputes. Now, generally from a trade perspective, a temporary export ban is permissible as long as it is, of course, temporary in nature. However, from an investment perspective, such export bans, given that they're governmental measures, have the potential for investment claims. Here we have a map provided by the WTO on states that have taken trade-related measures throughout the COVID period. The map is somewhat deceiving in that it also includes countries that have taken measures to facilitate trade throughout, but a number of countries have, of course, taken measures to restrict trade, and that's notably been in the medical sector, but also in the food sector. We've seen a significant number of countries start stockpiling certain key food products to ensure that they'll have food for their population. This has been in relation to rice, as well as other sort of staple food products. So if we just go to the next slide, we can see a few of the coverages that have been affected by export bans. So these are, potential sectors where investment claims may be, where we may see investment claims in the future. That being said, I should note that a significant number of the export restrictions have already been lifted. Pursuant to the WTO, WTO member states are required to inform the WTO when they both put in place a trade restrictive measure, but also when they take such a trade restrictive measure away. So one of the, good things we're seeing is that states are, in fact, complying. They are telling the WTO when they're putting such measures in place, but also informing the WTO when they are being taken away, and at least a certain amount of those measures has been taken away to date. Kristen, over to you. I guess one more thing. In relation to not so much trade, but as we're seeing sort of on a cross-sector basis, a significant increase in fraud. This has been seen in medical products specifically, in cases that we've seen, but also just sort of across the board, there's been a significant increase in fraud. Again, the potential for disputes to arise between companies. Fraud is being done on a both good faith and bad faith basis, i.e. you could have a contract with company X in a separate country. They could be on a good faith sending you materials, but some of those materials may in fact be fraudulent. In other instances, it has been complete fraud. So one other issue that we're seeing that could generate disputes moving forward, if they have not already, if you're a company and you're looking to avoid these, a review of your internal policies to ensure robust anti-fraud measures are in place would be a good thing to do at this point. I think now we'll turn it over to Kristen to go on a more deep dive into international commercial arbitration.
Thanks, Sean. So as you just walked through, governments are taking extraordinary measures around the world to address the spread of COVID-19. And while many governments are trying to strike that balance between protecting public health and economic interests, the pandemic is creating unprecedented risks for companies all over. And this has resulted, as you can see on the slide here, in an explosion of litigation related to COVID-19 in the jurisdictions that the three of us practice in, namely the United States and Canada. There are nearly 3,300 cases that have been filed in the United States in both state and federal courts. Of these, a handful relate to foreign entities. Some have been filed against China or its government agencies, and another 3 have been filed against foreign sovereigns or NGOs. Now, these numbers are just as of mid-May, so surely they have increased in the past 2 months. And while Canada is not known to be quite as litigious as the United States, even Canada has seen an uptick in lawsuits, including in class action lawsuits, which we've seen a lot of in the United States as well. We would expect to see these numbers balloon even further because, as many of us know, courts have been shut down in response to the pandemic. As courts ease those restrictions and open themselves back up to both essential and non-essential court filings, we would expect that the number of cases will rise even further. Now, against that backdrop of litigation and how the pandemic is impacting litigation, we wanted to spend some time talking about commercial arbitration first and then investment state arbitration later. Because while the pandemic has certainly slowed the flow of arbitration, because arbitration tribunals are not subject to the same court shutdowns as U.S. and Canadian courts, there have been arbitration activities that have been ongoing. And we see that the disputes are picking up as a result. So first, let's just take a step back. When we refer to international commercial arbitration, we're talking about situations where parties have agreed in their contract to refer their disputes to arbitration rather than to the local courts of the United States, of Canada, or of anywhere else. And that these relationships have an international flavor to them. So whether that be companies from one country having a dispute with companies from another country, for example. And one of the biggest questions that are facing these companies right now and their lawyers is whether or not this current COVID-19 pandemic situation constitutes a force majeure event that would entitle a party to excuse their performance of contractual obligations. So what does it mean to have a force majeure contract, clause in your contract, rather? It's a provision in the contract that covers extraordinary or unforeseen events or acts of God. These events need to be outside of a party's control and have such an impact that a party is unable to perform their contractual obligations. The effect of having this kind of clause in your contract is to excuse a party from performing its end of the deal. And in some cases, that would even extend to making adjustments to, for example, contract schedule deadlines, or perhaps to adjust prices that are in a contract. And because these clauses can significantly impact a party's obligations to perform, the courts in general interpret these clauses very narrowly. Generally speaking, unless your contract explicitly refers to a pandemic or to a disease, it can be difficult to utilize a force majeure contract to apply to this COVID-19 situation. Let's go on to the next slide. So even if your contract does refer to a pandemic in the force majeure clause, assuming that you have one, a party still needs to demonstrate that they can meet this exceedingly high bar that courts in general impose. That standard is going to vary across jurisdictions. So your first step will be to review your contract and determine what law governs, because the standard may vary. Once you have checked your standard, you will need to go on to try to develop facts that demonstrate your inability to perform. So it's not simply that your performance is harder or more expensive in this environment, but rather that it simply cannot be done, and that it was unforeseen, that there were no steps that a party could have taken to mitigate the impact of this pandemic. The pandemic isn't going to be an open-ended excuse to excuse a party's performance or lack thereof. Rather, parties are going to need to demonstrate a causal link between the pandemic and their inability to perform. Again, it's not just that it is harder or more expensive. Rather, it is that it is incapable of being performed. For an example, let's think about a construction contract. If a construction company is working to meet the deadlines and find that they are unable to meet certain schedule milestones because they can't get staff on site because there are travel restrictions that are imposed, that would perhaps be sufficient to establish a causal link between the pandemic and the inability to perform. But simply having higher prices, for example, that may not be sufficient. Then a party needs to think, what steps could it take in order to mitigate the impact of the pandemic? Again, taking the example that I just cited, can a company pivot to find supplies and materials from another supplier, even if it is at a higher cost? Or can a party switch its manufacturing to a different facility that is less impacted by a COVID flare-up or other kinds of governmental restrictions? So these are the steps that a party needs to think through to see whether or not it has mitigated the impact of the pandemic. Next slide. So determining whether or not a party's performance can be excused due to the pandemic is going to be an extremely fact-specific inquiry. You'll need to evaluate your individual circumstances one by one, starting first with the contract language, second with the applicable law of your jurisdiction, and third with the facts. This is not going to be one size fits all, but rather an individualized inquiry. And it really boils down to these three primary questions that we have listed here on this slide. One, is the event a qualifying force majeure event? Could a party foresee the non-performance and take steps to try to avoid the impact? And finally, was the performance truly impossible or just more difficult than we would have wanted? So as I mentioned, the standards are going to vary across jurisdictions. So you need to know your local law. Some countries have incorporated into their statutory codes a force majeure provision, which makes it quite a bit easier for parties to rely upon because it's built right into the code. Examples of states like that would be China, the United Arab Emirates, for example. But there are other countries, including the US and Canada, as well as the UK, which do not have a statutory force majeure provision. So instead, parties will need to build that into their contracts and rely on the contractual language alone. So what about the circumstance where parties have not had the forethought to incorporate a force majeure provision into their contract, or where their force majeure provision does not specify that it covers a pandemic such as this? What to do then? Well, there are some other defenses that may be available to a party in case they are unable to perform. And just quickly, we want to outline a few of those so that you can spot some potential defenses that you may have. The first one is impossibility or impracticability. The specifics, again, are going to vary across jurisdictions, but generally speaking, a party will need to establish that there has been an unanticipated event that has happened, that neither party anticipated that that would happen at the outset, and that it made performance impossible. This defense is going to focus really on whether or not performance is possible or viable. That is the primary thrust. The second defense that we've listed here is frustration of purpose. Now, this defense has a slightly different focus. It's whether or not the entire purpose of the contract has been destroyed by the event. And the basic elements are laid out here. One, the event needs to frustrate the purpose of the contract. Two, the parties need to have both shared a basic assumption at the outset that that event would not have occurred. And finally, that the event isn't the breaching party's fault. In addition to these defenses, parties would do well to review their contracts to see if they contain any other provisions that could be of use to them during this time. For example, there may be limitations on liability or provisions that exclude certain types of damages, which may be helpful to you. There may be contract variation procedures that are there, which would allow a party to request that there be adjustments to schedule timelines, prices, things like that, upon the other party's approval. And given that we are all working in these crazy times, companies are finding that their counterparts are sometimes willing to negotiate and reach new deadlines or prices because we all understand that we are working in a new dynamic right now. So look at your contract, see if it has a material adverse change clause in it. It may be of some help to you. What's become clear over these past several months is that this global pandemic is going to have far-reaching implications to economies, to companies, to the employees who work at those companies, and we all need to make adjustments. As one part of the world seems to get its COVID-19 virus situation under control, other countries may see a hotspot flare up. And so that's going to impact the way that business gets done for quite some time, and we're going to have to be living with these effects for a while. So in light of the fact that we anticipate this will be a long-term situation, we also wanted to pause here and look ahead at what the future may bring in terms of dispute. We see that many companies have had to institute financial resiliency measures, some downsizing of employees and staff potentially, and that could hit companies' compliance departments. This could have long-ranging impacts because as companies are scrambling to win more work, to hold on to the work that they have in order to survive this challenging financial moment, there may be some impetus to engage in some risky behaviors right now. And we believe that it's likely that there could be disputes that arise out of unfair competition, potential fraud claims in the future. This might extend to governmental investigations into illegal activities. For example, we might see in the U.S. government investigations under the Foreign Corrupt Practices Act, or FCPA, that might see an uptick in the future, and that may spin off other kinds of arbitration proceedings and litigations in court. So the situation and the actions that companies and their employees are taking today are likely to lead to arbitration down the road. So now, Diora, do you want to take it from here?
Thank you, Kristen. Before we move on to the investor state arbitration, as we mentioned at the beginning of the webinar, we need to take a brief moment to satisfy CLE requirements by delivering the following code word. All New York and New Jersey attendees must type the code word arbitration onto the Q&A section on the right-hand side of your WebEx screen. Please make sure to hit send button so that it registers. In case you missed it the first time, the code word is arbitration. So now that we've covered international commercial arbitration context, in investor-state arbitration context, the question is whether measure taken by the state in response to a COVID-19 pandemic could provide a legitimate basis for claims under bilateral investment treaties, multilateral investment treaties, or other investment protection instruments. So we will first focus on this and then identify some of the defenses that may be available to the states. Namely, even if an investor, for instance, is able to establish that there has been a breach of investment protection, right, states parties, as we have seen from past experience, may nonetheless have one or more valid defenses to claim a violation, for example, against investment right. Such defenses, which Sean will discuss shortly, may establish either a specific, based on a specific wording of a treaty or instrument code at issue, or they may be available under the customary international law. So let's first talk about measures. It should be noted that given an unprecedented situation, we are yet to see whether the claims that arise as a result of government measures would in fact satisfy international law standards that tribunal will apply. Taking a step back to the language of bilateral investment treaties, we note that many bilateral investment treaties include a provision that relates to compensation or reparation in time of war or conflict. Some of these clauses are in fact drafted more broadly to encompass the more general concept of national emergency and could provide an additional basis for claims. So, for example, one example that comes to mind is, for instance, the language of the Malaysia-Jordan Treaty, which you see on your slide, bullet point 4. This is a provision in the most favored nations provision in the treaty that, as you can see, provides protection to investors who suffer losses owing to war or other armed conflicts, revolution, a state of national emergency, which is applicable in this case, and insurrection or riot in the territory of the letter. So the examples of such treaties can come not only within the context of most favored nation clause, they could also appear in the compensation for losses articles or provisions of the treaty. For example, Barbados-Venezuela Treaty is an example where a treaty actually provides for compensation in cases of national emergency. In fact, it contains such language. So we see a number of treaties that contemplate a protection of investors and their investments in times like this. So, of course, the question becomes whether the merits of such claims will be successful. And certainly, this will be highly fact-specific, as Kristen already pointed out, in the context of international commercial arbitration. And there will be highly fact-specific both with respect to the state measures and the specific circumstances of the investments. Before bringing any claims, investors will need to consider carefully whether the measures taken by the state have potential to give rise to a breach of any of the protection standards commonly found in investment treaties. We will discuss them in a moment, but one point to keep in mind is that in past experiences, we have seen that investment arbitration, investor-state arbitrations, often follow economic or financial crisis. We have seen this on the example of Argentina in early 2000s, when the economy crashed, it led in subsequent years to more than 40 exit arbitrations. As some of you probably know, that claimant investors, those who were able to recover damages as a result of this crisis and losing their investments, are still in the process of enforcing their awards. We have also seen in the past that political instability can lead to claims by banks and financial institutions, and the crisis in the Russian Federation is one such example. So now, what things do you need to consider as you think of potentially bringing a claim against the state? You obviously need to identify whether the measure actually constitutes a breach. So as a first step, always consider jurisdictional limitations, whether the terms of the treaty agreement or any investment agreement includes any kind of or imposes any kind of jurisdictional limitations. For example, mandatory recourse to local courts, or mandatory cooling off period, as it's called, which is essentially a negotiations period. The protection standards, the substantive protection standards that investor might seek to invoke include, for instance, prohibition on expropriation without compensation. So we have seen that there are certain events that are taking place in this world, and we will discuss them in a moment, that could be qualified as virtualization. The question is whether enforced lockdowns or classification, for example, of businesses as non-essential and its impact might constitute indirect expropriation. So the issues like this need to be considered as the claim is being brought. Another protection standard is the right to fair and equitable treatment. The COVID-19 measures may be challenged by some investors on the basis of their proportionality, or, for example, on whether the measures may have been implemented unfairly against that particular investor, or, for instance, if they had any disproportional effect on certain investor, or simply unfavorably favored some sector players, national or foreign, while disadvantaging others. So another standard of protection that is often found in treaties is the most favored nation treatment or national treatment. And we may see the tribunal called on to consider whether state aid packages that are offered by various states to the local companies in a certain sector or to certain host state companies create so-called an uneven playing field. So these are just some examples of protections against governmental measures that are put in place within the treaties and how they can play out long term. So in terms of specific examples of government measures, we will talk in a moment on measures that have been taken in Europe, and I will pass the floor to Sean. But some of the measures that we have seen worldwide, we certainly seen the most drastic export restriction that came from India that held a 20% stake in the global generic drugs market. India, as you may have seen, invoked the Disaster Management Act that the country implemented back in 2004 as a result of the measures that are taking place now. China invoked a quarantine strategy and introduced extensive financial assistance to certain enterprises that are engaged in anti-epidemic work. We have seen in the U.S., the Trump administration invoked the Defense Production Act to ban export on critical medical personal protective equipment. We have seen in South America, Peru, one of the first ones, proposed a measure, emergency measure, suspecting the collection of toll fees on the country's road network in response to the COVID-19 outbreak. And by way of background, some of those countries' roads are administered by the foreign companies. So let's look at some, before we actually go to Europe, one of the really good examples, and it's actually very recent, just yesterday, it was reported that Zimbabwe's state-owned pharmaceutical company has been threatened by with a claim over termination of 60 million contracts to supply COVID-19 testing kits. And of course, they're also undergoing a criminal investigation. But that's another example of how the emergency measures are resulting specifically in the claims brought against the state. Sean, floor to you.
So a few other measures that could potentially give rise to investor-state claims would be some of the measures that I had previously mentioned, specifically the export bans on medical goods, whether that's gowns, masks, respirators, essentially measures that would prevent businesses from fulfilling contracts, prevent them from gaining additional contracts on the global market, assuming that the market share that they get globally would not be the same as the domestic market. Additionally, we've seen, specifically in Europe, a number of countries either thinking of or having already implemented nationalizations of key sectors, whether that be full-on nationalizations or some sort of partial nationalization. In Spain, for example, significant nationalization or thoughts of nationalization has gone into hospitals and healthcare providers. Italy, in terms of the airlines, I believe they've already moved forward with that. We've seen significant contemplation within the UK to at least temporarily nationalize airlines to prevent them from going bust. Obviously, airlines usually are subject to significant government subsidies and under fairly significant distress at the moment. And we've seen similar measures being taken in France as well. Considering this in the expropriation context, there are investment cases out there that sort of look at the context and say, if it's a nationalization, it must be effectively permanent. So if a measure is in place for even a fairly significant number or period, for example, in one case, the measure was in place for up to 18 months, and it did not constitute expropriation under that treaty, essentially makes it difficult to claim against temporary measures. But in the event that these are permanent measures or discriminatory measures, as Dura mentioned, in terms of favoring domestic companies over, for example, a foreign company, they could in fact be subject to investment claims. In addition to getting over the hump of having a valid claim under an investment treaty, which can be difficult in certain circumstances, in assessing claims, you also need to look at potential defenses, which could mitigate the success of any claim that's brought. So first and foremost, in assessing a claim in its totality, you're going to want to consider the specific treaty language. Are there any specific exceptions within the treaty that would allow a state to take measures that they have taken? Or are there any specific carve-outs? In a significant number of free trade agreements that include investment chapters, for example, there is a taxation carve-out. So if measures are implemented through tax, there is a decent chance that those measures will be or should not be subject to an investment claim. Other than specific treaty examples or treaty language that could potentially allow a state to take key measures throughout COVID that has negative impacts on certain businesses, you would also need to consider the general defenses that could be raised through public international law or that are available through customary international law. Many of these defenses track what you'd have in domestic or international commercial arbitration defenses, as Kristen had noted. However, they are rooted in international law, and the tests will be taken from international law specifically. So there are four principal or key defenses that can be raised. That is force majeure, necessity, distress, and police powers. Well, there's a general high threshold for all of these to be claimed and to be successfully claimed. They are still out there and could potentially be applicable to COVID and the situation that we're going through right now. Again, this is, of course, a fact-specific investigation, and through practice, we've seen it is quite difficult for a state to meet those thresholds. Specifically, force majeure and distress, it is unclear if those would be applicable to the particular COVID situation that we're in. Potentially necessity could be one defense that would just any investor would like to give or should give a hard look to, and potentially police powers in at least its modern interpretation. We've seen several cases recently which has given a fairly expansive interpretation to what police powers could potentially constitute. A few other key things that investors should take into consideration if they are in fact significantly impacted by claims. First, what to do and what not to do. Well, many investors will first seek recourse in the jurisdiction where their investments are situated. Certain investment treaties, and certainly many bilateral investment treaties, contain fork-in-the-road provisions. So while you can, of course, negotiate, while you can mediate, if you were to bring a claim based on the same issues in a local court and correspondingly bring an investment claim at the same time, your investment claim may be barred on a jurisdictional basis. So if you are an investor subject to such measures, it is good to fully consider the panoply of recourse that you have, whether it is contractual, whether it is under an investment treaty, to ensure that you're taking the right steps to preserve your rights under a treaty. Similarly, as Kristen noted, investment claims, of course, have to be causal, i.e., the damage suffered by the investor must flow directly from the state measure. So in the event that it is a specific COVID measure, it will be the claimant's onus or the investor's onus to show that the damage was in fact flowed from that measure. And also, even though it will be the very beginning stages, investors, of course, should consider enforcement. We've recently seen at least a few novel cases where essentially very public-related defenses have been asserted for enforcement, and we're seeing this more and more through academics writing about it and actual enforcement strategies being devised that potentially public necessity should be considered as a defense to enforcing an arbitration award after it is in fact rendered. So in effect, considering the totality of the situation for an investment claim should be something on everyone's radar. Getting counsel, both domestic and international, involved at an early stage if your business has been affected is, of course, a good idea.
So to pick up on that point, often given the ownership structure of foreign investments, more than one investor treaty could apply to the state measures that took place in light of this national emergency. So one of the things that we recommend to our clients is while comparing applicable investment treaties in a certain context, try to consider whether all treaties apply equally, whether they contain offer to arbitrate against the host state, whether a treaty contains, for instance, fork-in-the-road clause or mandatory cooling-off period that we've discussed before, whether the protection against illegal expropriation include actually indirect expropriation, because in most cases where nationalization is not one of these steps that was taken by the government, the potential claims could lie in claim of indirect expropriation. Under fair and equitable treatment, question arises whether legitimate expectations to a predictable and stable economy are guaranteed. There's also a question of whether the treaty protects the full, provides full protection and security of the physical assets, legal assets, whether it guarantees for national treatment protection that I discussed earlier, and whether whether these protections, in light of a national emergency, for instance, have been previously interpreted by any other tribunal. And just to wrap up the key takeaways on investor-state arbitration front, you see on your slide that foreign investors must protect their investments against improper state interference in this time of crisis. We recommend to investors to carefully consider how their investments are structured and whether there is a scope to restructure their investments in ways to maximize the protection. We also recommend our clients and generally to general counsel and board members to consult with the experienced counsel to ascertain their rights in light of the government measures that could be considered unreasonable, disproportionate, arbitrary, or discriminatory, because as we have seen in practice and we're seeing every day, they may trigger valid treaty claims. So over to you, Kristen, on the summary of strategic takeaways.
Sure. So we have covered a lot of ground in a little under an hour. We've flown through a lot. We started out by talking about how we are living in this totally new environment and how we are already seeing an explosion of claims, both on the commercial side and on the investor state side. So what do we do in response to that? Step one, check the terms of your contract and of your treaty. You need to review the written agreement to see where you stand. So on the commercial side, that means checking what kind of clauses that you have in there that could be protective. Do you have a force majeure clause? Do you have other contractual provisions that could be helpful to you? Is there an insurance policy that you can invoke? Clauses from another contract? What contractual tools can you marshal to protect yourself? On the investor state side, as Diora and Sean just walked through, you need to start with your treaty language. What does your treaty language provide? What does your free trade agreement provide that can allow you to press your claims? What kind of notification requirements are required in both circumstances? One thing that is clear that I hope has come through in this presentation is the need for everyone to understand what their governing law is and what the specifics of their jurisdiction require. We had a wonderful comment by one of our attendees noting the difference in provincial law. And so it's comments like those which really drive home the need for you to look at what the governing law of your jurisdiction is, particularly the distinction between common law systems and civil law systems. Is a dispute your only way out of your difficult situation right now? Consider whether there are alternative means to resolve your dispute. Again, I mentioned insurance. Can that be a solution? Can you mediate your dispute instead of arbitrate it? There are plenty of parties who are willing to work with one another at this time, and so you may be able to amicably resolve your issue before getting into an arbitral tribunal. Then consult your lawyers. Help yourselves by allowing us to help you by reviewing your contract, by reviewing your treaty language, to discuss what the potential claims that might be available to you are and what remedies you may be able to invoke. On the contract side, there are contractual remedies. You could request specific performance or restitution or certain kinds of damages, including punitive, liquidated damages, consequential damages. And the remedies that are going to be available for parties' breaches are going to vary depending, again, on what your jurisdiction is, what your clauses provide. You need to know that, and your trusted legal counsel can help you do that. And finally, consider enforcement issues. Even the best claim in the world isn't worth much if you don't have the means to enforce your award. So consider, where does your counterparty have assets? Are they at risk of going bankrupt or becoming insolvent? Because again, the best award in the world won't be worth the paper it's written on if you cannot collect on it. So there are a lot of things to think about right now, a lot of ways that companies and investors can position themselves well to respond to this challenging dynamic. The three of us are here at Dentons to help anyone out there who is in need of some assistance. We're happy to walk through any kind of commercial arbitration question you may have and any investor-state arbitration you may have. We love these issues, and we'd love to work with people who have challenging legal questions, and this COVID-19 situation is certainly a challenge for us all. So we thank everyone for joining here today. Let's take a quick look to see if there are any questions that anyone has. And at the end of our presentation, we have set forth our contact information. So please, should anyone have questions, please contact Diora, Sean, or me. We're available to answer any questions that you may have now or at a later date.
There's one question from Nationalisations. How are claimants affording to launch litigation arbitration in light of COVID's financial impact? What role can third-party funders play in the COVID landscape? Not sure if either of you would like to take a stab at that question.
Well, that's a great question. I think that litigation funders are always interested in finding interesting and rewarding opportunities. I think that this environment for creative parties can bring benefit both to claimants and to litigation funders. From the litigation funders' perspective, they're always looking for attractive and sound claims. So the better that a claimant can do to marshal its facts and its legal arguments, the more attractive a possibility it will be to a litigation funder, I believe. But I certainly think that the cash crunch that so many companies are experiencing will impact the ability to bring claims. That's my 2 cents. Diora, Sean, anything to add?
And just to add just one more thing to what Kristen already pointed out, we have certainly seen that, based on the various publications, that third-party funders are, gaining more appetite in light of this COVID landscape, as you pointed out. So one of the main considerations in our experience for the third-party funders is the viability and potential success of the claims. So the analysis, based on the points that we've covered in our presentation on success of the potential claims, either in investor-state arbitration or commercial arbitration, and consideration of defenses is all something that third-party funders are looking at, considering on a case-by-case basis. So we can certainly see their role only increasing. Any other questions? Be happy to answer.
Well, it looks like that may be the end of our questions, and the three of us are available should any come to any of our attendees later. And thank you so much for joining us at this presentation.
Thank you very much. It's been a pleasure. We hope to be in touch.
Great. Thank you.